Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to have a look at Bill C-22, which is titled An Act to Amend the Criminal Code and the Controlled Drugs and Substances Act. This is proposed legislation. It's not in force at this point, but it's been very controversial. There's been a lot of comments about it, and I'll have some comments of my own. But I want to unpack this one and explain what it's doing and sort of how, and then we'll go through it. I'm going to have to jump between this and the legislation that it proposes to amend, because otherwise it's not going to make a whole lot of sense. So we're going to be jumping back and forth a fair bit for this video. So we see here, this is Bill C-22. Subsection 85 sub 3 of the Act is replaced by the following. Punishment. Every person who commits an offense under subsection 1 or 2 is guilty of an indictable offense and liable to imprisonment for a term of not more than 14 years. Most of you probably heard that and said, I don't know what that means, because you don't have the context. What is subsection 1? What is subsection 2? What is this changing things from? Sometimes when we have these bills, they'll have the sort of details of what they're changing here kind of put in the bill. We don't have that. So let's jump to the criminal code here. We see 85 sub 1 is using firearm in commission of an offense. And 85 sub 2 is using an imitation firearm in commission of an offense. So we see subsection 3 is the punishment section. That's what's getting replaced. And the main change here is that for a first offense, there was a mandatory minimum, or there currently is a mandatory minimum of 1 year. And for a second offense, there's a mandatory minimum of 3 years. And you might be thinking, that's excellent, because if I get robbed with a firearm, I really want to, I want that person to go away for a long time. The problem is that not every using a firearm in commission of an offense is going to be something serious like what you're thinking. In fact, lots of them may be substantially less serious. So I'll talk a little bit about my feelings on mandatory minimums, which is I'm not hugely a fan. There's a few problems that I see with mandatory minimums. The first problem is that the people you think, that should be hurt by this, the people who are real bad actors, don't typically get the minimum regardless. If the minimum wasn't there, they'd still get a larger sentence than that. So that's the first problem. The second problem is that it puts a lot of power in the hands of the police and the Crown, and that power is most effectively wielded against people who haven't really done the offense. Because if you're sitting there and the Crown is saying, listen, plead out to this lesser offense, and we'll give you 30 days in jail, and maybe we'll let you serve it on weekends so that you're not even going to lose your job. But if you don't plead guilty, we're going to proceed with this, and we're going to ask for a minimum punishment of 1 year. So if you get convicted at trial, you'll face a minimum of 1 year in jail. Lots of people may quite reasonably say, I didn't do it, but I don't want to risk a whole year in jail. Like, that would be life destroying, so I'm just going to take this lesser punishment, even though I feel it's unwarranted. And, so that these mandatory minimums can in that fashion be used to bully people into guilty pleas. And that, in my view, is a bad thing, especially because that particularly affects the people who maybe haven't done it. The other issue I have with mandatory minimums is that the people they do affect are typically the people who are most deserving of a break. You're not really affected by a mandatory minimum if you're looking at getting 7 years for the using of firearm in commission of an offense. You don't care that there's a mandatory minimum of 1 year if 7 years is sort of the ballpark. But you do if the court would have given you less than a year. And the court in the case of the Queen and Nur, which is a case I've covered previously, has basically said that the appropriate way to look at whether these mandatory minimums are appropriate is to consider what's called a reasonable hypothetical, which is, can you imagine a sort of reasonable circumstance where somebody's being charged for this, where they should get less than a year? And the example that sort of immediately springs to mind here is, let's say you there's somebody who keeps parking in your driveway or blocking your driveway, and you really hate this guy, you're really upset, and you go out and you slash his tires. That is a criminal offense of mischief. You are going to get punished, but you're not going to get a year in jail for that. But let's say you happen to be a carpenter, and so instead of grabbing your, a knife or something like that, you still want to do the same thing of mucking up the guy's tires, but you just go out there with a nail gun and put a couple of nails through the sidewall, and that's the way you decide to do it. Well, now that nail gun counts as a firearm for the purpose of this offense. So because you decided to slash the guy's tires with the nail gun instead of with, a knife or whatever else, now you're potentially looking at a minimum sentence of 1 year in jail. That to me doesn't make a whole lot of sense. I mean, the person who punctures somebody's tires with a nail gun should get some punishment. That is a punishable behavior. But it doesn't sound to me like a year's worth of punishment. That's more of a lesser kind of offense, at least, the first time. So that's kind of the first bit there. Let's go through and see some more provisions as to what this all changes. So you see subsection 92 sub 3 of the Act is replaced by, and it's very similar language, term of not more than 10 years. So when we scroll down and have a look at 92 sub 3, 92 is possession of firearm knowing its possession is unauthorized. And previously there were mandatory minimums for a second offense and for a third offense. So once again, they're getting rid of those mandatory minimums. We can also see it amends 95 sub 2 in the same way. And 95 sub 2, if we scroll down a little bit, is possession of prohibited or restricted firearm with ammunition. It doesn't have to be loaded, but it's readily accessible ammunition. And all of this is without having a license or registration certificate or whatever else. And you might be thinking, I want mandatory minimums for these people. These are bad people. And many of the people charged with this will indeed be, bad people. But not all of them, because this is exactly the circumstances in the case of the Queen and Nur. And in that case, which I described in some detail in another video, the Supreme Court struck down. So this is actually already struck down by the Supreme Court, but they struck down this mandatory minimum. And the reason why is because this is one that could actually really hit a law-abiding gun owner who just screws up. Because let's say you are, you've got a whole bunch of handguns, you're a target shooter, and you don't realize that your firearms license expires. And so now you're in possession of a restricted firearm because you've got handguns, and you've probably also got ammunition because, if you are a target shooter, you probably have ammunition because how else are you going to target shoot? I don't think that a person who lets their license expire but had a license, isn't involved in any criminal activity, the only thing they've done is accidentally let their license lapse, should be looking at a minimum punishment for 3 years. And the Supreme Court agreed. The reasonable hypothetical that they accepted for striking down this mandatory minimum was the ordinary gun owner who lets their license lapse or forgets or something along those lines. So I don't have a problem striking down this mandatory minimum because, if I screwed up in some big way, this one could be used against me for a paperwork blunder. And I don't think anybody should go to jail for 3 years for a paperwork blunder. If we go back, we see 96 sub 2 sub A. Again, they're getting rid of the mandatory minimum. And what is that? That's possession of weapon obtained by commission of an offense. This one also has a mandatory minimum punishment of 1 year that the legislation would get rid of. And you might be thinking, well, come on, this one seems reasonable. The example that I leap to here is, again, the nail gun. Let's say you have never committed a crime before, but you start off by stealing a $200 angle grinder from Home Depot. For that, you wouldn't be looking at a mandatory minimum punishment, and you certainly wouldn't be getting a year in jail if that was your first ever crime. But if instead you steal a nail gun, That nail gun will count as a firearm for the purposes of this particular section, not for some other sections, but for this section it would, at which point you would be in possession of a firearm that was obtained by commission of an offense and looking at a mandatory minimum punishment of 1 year, even though that nail gun is really just a tool, and a tool worth the same amount as the angle grinder. $200 angle grinder, you're not getting a year. $200 nail gun, how is that super worse? So this one, again, I can see a reason or a situation where the mandatory minimum punishment is potentially a problem. Skipping ahead, we see section 99 sub 3 and 100 sub 3. Again, they're getting rid of some of the mandatory minimums, and those are weapons trafficking issues. So you might be saying, wait, why would we get rid of mandatory minimums for weapons trafficking? Well, let's say you're a father and you've had an air rifle in the family for a good long time and you pass this air rifle on to your kid. Well, C-21 may well make that illegal by making that air rifle a prohibited device in Canada. If it's one of the Canadian specialized models that have been cut down below 500 feet per second for the Canadian market, at that point, you'd be committing weapons trafficking. Whoops. Should you be looking at 3 years in prison if you did that? I feel like no. So again, there's situations here where I think maybe, these mandatory minimums are a little too harsh. However, when I think about the guy who made the news recently for smuggling a whole bunch of handguns in a duffel bag, he doesn't care about the 3-year mandatory minimum because he's not getting 3 years. He's getting well above 3 years, assuming he gets convicted. That's a situation where the mandatory minimum just doesn't bother you because you're above it. So I don't like mandatory minimums in these kind of situations where I can think of somebody who might deserve less and get hammered by it, particularly, again, because they might get bullied into guilty pleas. Now, let's look at the rest of the criminal code bits fairly quickly here. 121 sub 1 sub 4 sub A. This is basically tobacco without paying the proper excise taxes. I don't really care about a mandatory minimum on that one because it's really not an offense that hurts anyone other than the government not getting their proper, their cut. So I'm okay with getting rid of that mandatory minimum. Now we get into 244, which is discharging firearm with intent to wound. You might be thinking, whoa. And I kind of think that on that one, maybe a mandatory minimum is more justifiable, but I might just not be thinking hard enough about it. It might be that there's examples that come up where I go, okay, maybe not. When we get to 244.2 sub 3 sub B, if we jump over to the criminal code, that is discharging a firearm that is reckless, which includes intentionally discharging a firearm into or at a place, knowing that or being reckless as to whether another person is present in the place. So doing a drive-by at a house. And my first inclination is somebody who does that is a bad person and deserves to go to jail for a long time. But then I think, wait a minute, lots of things count as firearms that maybe aren't sort of our usual conception of a powder, real steel firearm. How do I feel about somebody getting 5 years for if they fire a paintball gun at a house? Let's say that they fire that paintball gun at the house and they know that there's another person who lives in the house, but they also know that their paintball gun is not going to punch through the door. Paintball does not punch through a wooden door in any circumstance I can imagine. Should they get 5 years for firing that paintball gun at the house, knowing that there's another person who's present in the place, but also knowing that they're not going to hurt anyone? I kind of feel like 5 years is too much. I mean, that might be something that we want to say, yeah, that's a crime. Somebody's going to have to clean all that paint off. Maybe you would have scared some people. But 5 years? Well, maybe not. That's assuming that the assumption on that is that you're shooting, a handgun or a rifle or something like that at the place. So I can think of a situation there. We get into robbery and extortion with firearm. Again, I'm not seeing, thinking right off of where this goes wrong, but I'm probably not thinking about it hard enough. So, again, I'm not a big fan of mandatory minimums. Some of the mandatory minimums in this, I think maybe I might have kept, but I would have spent some time thinking about this, and maybe they've thought of examples that I haven't. We can also see in the Controlled Drugs and Substances Act, they've gotten rid of a bunch of mandatory minimums. And when we look at the Controlled Drugs and Substances Act, trafficking in substance, if it's Schedule 1 or 2, mandatory minimum punishment of 1 year. And they also have for 6, which is importing and exporting. Again, mandatory minimum punishments. Again, I'm not a huge fan, especially when you're talking about possession for the purpose of trafficking. Trafficking can be, I'm a drug dealer on the street and I'm a really bad person. I'm moving kilograms. I'm, whatever else. Or it could be, one of the most common forms of drug trafficking prior to this was when you had people passing a joint. That's not, marijuana has been substantially decriminalized, but, if you've got two people who are sharing drugs, possession for the purpose of trafficking. This will also get rid of mandatory minimums for paragraph 6, which is import-export, as well as paragraph 7, which is production. You might be thinking, whoa, that's a bridge too far, because you're probably thinking of people like Heisenberg who are, making meth in quantity and supplying their town and so forth. I can still think of some substantially smaller scale operations where maybe the punishment might be a little too harsh in the mandatory minimums because they rely on our assumptions there. Now, I'm going to skip ahead to some interesting bits that they've also added here, which are evidence-based diversion measures. And this is some sections where I'm just like, what is going on here? What are they doing? Declaration of principles. All right. The following principles apply in this part. A, problematic substance use should be addressed primarily as a health and social issue. Intervention should be founded on evidence-based best practices and should aim to protect the health, dignity, and human rights of individuals who use drugs and to reduce harm to those individuals, their families, and their communities. Criminal sanctions imposed in respect of the possession of drugs for personal use can increase the stigma associated with drug use and are not consistent with established public health evidence. Interventions should address the root causes of problematic substance use, including by encouraging measures such as education, treatment, aftercare, rehabilitation, and social reintegration, and judicial resources are more appropriately used in relation to offenses that pose a risk to public safety. So, I generally agree with these. I am not a huge fan of the war on drugs. I think that the war on drugs and our banning of drugs is a major driver of violence within society. That said, a declaration of principles doesn't really do much. This isn't going to have a whole lot of legal effect. It'll be really interesting to see if this gets implemented, if the courts use it at all. But it's kind of just fluff. However, there are some other provisions here. Warnings and referrals. A peace officer shall, instead of laying in information against an individual alleged to have committed an offense under subsection 4 sub 1, consider whether it would be preferable, having regard to the principles set out in section 10.1, to take no further action, to warn the individual, or with consent of the individual, to refer the individual to a program or to an agency or other service provider in the community that may assist the individual. And subsequent charges not invalidated. The failure of a peace officer to consider the options set out in subsection 1 does not invalidate any subsequent charges laid against the individual for the offense. What does this mean? It means a whole bunch of BS. A peace officer shall. Shall is normally very strong language when we're talking about the law, because it means you must do something. But they must consider. So they can say, wait, yeah, I thought about it, and I decided not to. Like, they don't have to, there's nothing here that gives you any remedy. Similarly, it says the failure of a peace officer to consider the options doesn't invalidate any subsequent charges. So if you go into court and you say, they didn't think about whether they should just give me a warning. The officer can get up on the stand and say, yeah, didn't think about it at all. Didn't care. Section 10.2, I think it's BS. I'm not going to look at it. And this says it's perfectly fine. There is no remedy that you can get for this. So a law that does nothing other than tells officers to maybe think about a thing sometimes is kind of a useless law. I mean, maybe this should have been an email rather than a legislative statement. This I find a little frustrating, but it is what it is. There's no teeth to this. There's nothing that you can use for it. Prosecution limits. A prosecution may be commenced or continued against an individual alleged to have committed an offense under subsection 4 sub 1 only if, and 4 sub 1 is simple possession, so personal use possession. Only if, having regard to the principles set out in section 10.1, the prosecutor is of the opinion that the use or warning or referral under section 10.2 or of alternative measures is not appropriate and a prosecution is appropriate in the circumstances. Well, of course they're proceeding if that's their opinion. Again, this could have been an email rather than putting this into a law, because why would they be proceeding unless that was their opinion? And you're not going to be able to get the prosecutor up on the stand to talk about their opinion and, how they're exercising their discretion. So these are basically just saying that the discretion that already exists in the law and is already very commonly used should continue to exist, and thumbs up to it. This is entirely fluff, and I don't like it when they put fluff into laws, because why? Record or warning or referral. So the police force can keep a record of any warnings or referrals. They can keep notes, so they can decide that maybe you've had 6 warnings. They don't want to give you a 7th warning. The only bit, and of course they could keep a record. I mean, they don't need this law to tell them that they can keep notes. I don't understand that. The only bit in here that actually does anything and actually makes some sense is evidence of warning or referral not admissible. So evidence that an individual has received a warning or referral mentioned in subsection 10.2 sub 1, or that they've taken no further action, and evidence that of the offense are inadmissible for the purpose of proving prior offending behavior in any proceedings before a court in respect of the individual. So at a bail hearing or a sentencing, they can't say, we've given this guy 6 warnings before, and so he should get extra punishment. This makes sense to me, because if you are getting a warning, it means you don't get a chance to prove your innocence. Let's say you are walking down the street and you've just bought, some rock candy or something along those lines, and an officer is having a bad day and thinks it's meth and takes your candy away and gives you a warning about possessing meth, and you're like, it's not meth. If they were able to use that warning against you, you'd never really have a chance to prove your innocence. It would go down as, this is a guy who has meth, but you never had the meth, and you wouldn't ever have that chance to prove that you didn't have the meth. So this bit I kind of like. If you're going to have warnings, then the warning shouldn't be held against you, because otherwise, what is the point of a warning? So, that is a lot of stuff going on in this one, but primarily what it's doing is getting rid of mandatory minimums, which I generally like, because I'm not a big fan of mandatory minimums. However, the timing of this is something that people have commented on, because they are somewhat ratcheting down the penalties for firearms offenses. Again, for most of the sort of bad actors out there, this isn't going to affect them much at all, but there may be some corner cases where it results in a slightly reduced sentence. At the same time, they're increasing and creating all sorts of new penalties that go after solely people who have gone and gotten a firearms license. And they're really, a lot of these laws may be quite bullying in effect. When you look at C-21 and the banning you from having handguns in a municipality, you're going to have to make the decision, if you are a sport shooter, but they don't like your particular sport, Are you going to move, out of town? What happens if you have a business there that deals in firearms or that is a range? These people may end up losing their livelihoods. They may end up getting pushed out. So for a lot of gun owners, this really feels like a kick in the teeth because, they're saying these other people were going to ratchet the penalties down, but you who have done your best to follow the laws, we're going to implement all of this new stuff to go after you. And yeah, it feels like the timing on this could be a little better. Notwithstanding the fact that I generally like the ratcheting down of mandatory minimums. I would like to see more of that. In fact, not less. I'm not a big believer that you can punish your way out of most social problems. And a lot of the problems that come up actually come up because we ban too many things, not because we ban too few. The general social notion of, if we just punish drug dealers enough, there won't be any drug dealers, is one I don't really buy into. Even in countries where the punishments are super harsh, they still have drug dealers. And there's always, I think, going to be people willing to take that risk, willing to step into those shoes. So I'm not a big believer in mandatory minimums. And there's probably also going to be people who are watching this going, wait a minute, Runkle, are you saying that the Liberal Party did something good? And kind of. On balance, I like this bill. I am not really a, party flag waving, my party can do nothing wrong, the other party can do nothing right kind of guy. And so when I see something like this that I like, I will say, I like this. And I recognize that I'm probably going to get a whole lot of people who are super ticked at me for saying that. But I'm here to provide sort of my take on things and to provide my comments and so forth. It doesn't do you any good if I just kind of tell you what you want to hear. I think that by and large, this makes sense. In several places, these are places where the court has already struck down the mandatory minimums. So, yeah, let me know in the comments below what you think. I suspect that there's going to be a whole lot of people disagreeing with me, and that is fine too. I am hoping that even if you disagree with me, we can still be friends. Please like this video. Please share it with your friends. Please subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Sir Daniel Wicks of Alberta, Jason Elliott, Demo, Canada's National Firearms Association, North Central Process Service, Kyle Martin, and Jean-Guy Toussaint. At the $20 level, Dale Nesbitt, Cameron Johnson, and Andrew Elsich, as well as at the $30 level, Sights and Arms Limited. Also a number of you at the $10 level who will be in the crawl immediately following. Thank you once again for watching, and I hope this has armed you with knowledge, and I hope nobody's too upset with me. Anyway, see you next time.